Okay, now let's go to the next era so that we can kind of illustrate some things. And that is the allotment era. So first we need to talk a little bit about what allotment means and its where it came from. The term allotment would, for the most part, people think Dawes General Allotment Act, written by Henry L. Dawes, Massachusetts, 1887. Okay? 1887 is quite a long time after the establishment of these reservations. If you go back and you look at the treaties of removal, right, then you will find the treaties of removal for the 5 tribes. You will see references to, the sort of allusions to the idea of eventually taking land individually. But then, if you look at the constitutions of the 5 tribes that were rewritten in duress in 1866, remember the 5 tribes, or at least one part of the 5 tribes, in the case of the Cherokees and the Creeks, sided with the Confederacy. So all 5 of the 5 civilized tribes, they were all slave owners, and at least one faction within each one of those tribes, in case of Chickasaws and Choctaws, they were Southern, they were all with them pretty much. Cherokees and Creeks were split, Seminoles split, and because there was this faction that was allied with the Confederacy in a formal way through treaties, okay, the United States federal government abrogated their treaty. So basically, they're saying that as a tribe, you have committed treason, and because of that, our relationship is broken, and you'll get a new constitution, and they took the western lands, basically the western part of Oklahoma, from those 5 tribes, including like the Cherokee Alley. So in 1866, all of the 5 tribes had to have their constitutions rewritten, and in every one of those constitutions is a clause that says, at any time in the future, when the tribe wishes to do so, the federal government will take the expense to survey the land and so that it may be distributed to individual citizens of the tribe. In other words, the thought of allotment was there in 1866, and it was probably there a lot earlier. Okay? So anyway, the allotment was there, and it was always kind of in the back of the minds of the Indian office people. You can go back farther than that, though. Thomas Jefferson, who was, one of the early sort of sources of Indian removal. I mean, after all, Louisiana Purchase was bought under Jefferson, and he had ideas about what he was going to do with that land, right? It's a place we can move the Indians and get them out of the way. But he had other ideas that, eventually, his idea was that eventually, if you moved the tribes out of the eastern United States and moved them to the Great Plains, moved them to Louisiana, today Oklahoma and Kansas, Nebraska and stuff. If you move those eastern tribes out, by the time the United States frontier got to the Great Plains, which must be centuries from now, then those people will have acclimated, they would have adjusted, they would have become part of us. That was sort of his idea. I'm sure he said it a lot more eloquently than I did. But anyway, Jefferson had ideas that eventually the Indians would take up farms like the rest of America, and by the time that if they removed them, then eventually, we would be one big happy family. Okay, so the idea of allotment goes way back. In fact, when the Choctaws were removed out of Mississippi, there were actually some deals made with some of the Choctaws for allotment. So you see allotment going all the way back to the 1830, okay, the idea of an allotment. So some individuals got their own land and got to stay there. So 1887 is the Dawes Act. Again, I talked a little bit about the movers and the shakers of allotment and who they were. You know that they were, for the most part, people who were trying to do some good for Native peoples. They realized that the situation on Indian reservations was dire for most Native people. They realized that Native peoples had been living in situations where they are often taken advantage of by the non-Indians, by the whites. Okay, they realized that socially Native peoples have had their world turned upside down on them, right? So the Dawes Act was, the idea of allotment was intended to be sort of a reform movement, a way to allow Indian people some relief, to allow them to have some property. And it's important to remember that, because the people who were behind allotment they honestly believed that this was for the good of the Indians, for their long-term social well-being and material well-being. They thought that if they didn't do something like this, then this is just going to get worse. It's just going to be an absolute disaster. You'll run into people who believe that the whole allotment process was just a big scheme to get the land. Well, to a degree it was, but that was not the original intent. Like so many programs, what happened here is you had reformers who had everything. Their intentions were very, very good and charitable. However, they found themselves allied with people who had ulterior motives, right? And those ulterior motives included, for the most part, land-hungry settlers in the Middle West, because by 1887, a lot of the very best lands had already been taken up by homesteaders. In places like Indian Territory, those were some of the more better watered lands and more potentially productive lands compared to like western Kansas or western Nebraska, which were actually settled by the 1880s. And there were people in western Nebraska and eastern Colorado who were getting forced out of some of those areas on the high plains when the droughts came in the early 1890s. So this was actually a period of duress in the high plains. But the Dawes Act itself was an intentional, an attempt to bring better conditions to Native peoples on reservations. But it became very much allied with people who were wanting that surplus land, wanting the potential land that would be opened up when Native peoples would be placed on allotments. So, the Homestead Act in 1862 doled out 160 acres to each head of household. What did you have to do to get a patent or a title to that land, deed to that 160 acres? You just have to go file for it, and that's yours?
You had to farm it, right?
What?
Did you have to farm the land?
Well, you had to occupy it. Yeah, you had to occupy it, and maybe the term improvement was there, but for the most part, what it required was an affidavit after 5 years from a neighbor, a couple of signatures, and then a nominal filing fee at the general land office, and the land was yours. Basically, you could claim it, and as long as you got your signatures, you could do it. Most people did intentionally settle on it and try to get started on it with a farm or something. Not everywhere, but for the most part, in this part of the world, they did after the land rents. And so anyway, after so many years, after the period of occupancy that you had to have, you had to be there for so long, and you got title to that land, what did that mean? Well, it was a great idea, wasn't it? I mean, the federal government was giving you a big start. How many of you would take 160 acres if the federal government was willing to hand it over to you now? I would. And this is, where's the land coming from? Something called the public domain. It's the land that has been cleared of Indian title and is owned by the federal government. So we still have a lot of that land, by the way. It's mostly in Nevada. And not a lot of people are, trying to get it. And you can't get it. Okay, the Bureau of Land Management, the federal government stopped giving out homesteads, at least outside of Alaska, quite a long time ago. Anyway, the people were wanting that federal public domain land for themselves, and railroads also may have been in on this, but there was quite a good lobby for opening up Indian reservations for non-Indian settlement. And the argument that they had, the argument that these farmers had for the most part was, this is public land. This is owned by us, owned by the people, but it's being utilized, or it's not being utilized by the people who have control over it. So there's that Lockean justification of property again. Remember that? The idea that if land's not being utilized, then really somebody doesn't really have the right to it. Now, the federal government never said that. The federal government said that, and people like Dawes said, what we need to do is eliminate this huge area of communal property in this reservation, this huge area of communal property that nobody owns because, yeah, it's the reservation land and the whole tribe has access to the whole area. That's the idea. But when everybody owns it, nobody really owns it. Okay? So there's no ability to have a title, and the key is really about disposal. Now, all of you that took that 160 acres from the federal government, what are you going to do with it? Live on it? Farm it? You're going to college. You want to farm 160 acres? You must be going to grow marijuana or something. Not yet, but maybe a year or two. You can be doing that, Oklahoma. Now that's one crop I could say, okay, I could probably make some money at that. All right? But 160 acres of wheat will get you nowhere. All right? And that's pretty much what we can grow around. 160 acres of hay meadow. You have a year like this with all this rain, there's no point in even cutting it because everybody's got hay and nobody's going to pay for it. That's the way it goes. Okay, but 160 acres, if you had title to it, at least you could sell it, right? If you had a title, you could sell it. Maybe you could sell it for nothing. Maybe, $1,000 an acre. $160,000. Sell it to some, tract housing developer.
Why would you sell it?
Well, because you got it free from the government.
I'm just saying, you still make
Yeah, I'd sell it. If I didn't want to farm it, if I didn't want to have it as my ranch or something like that. But yeah, if I could go cash it in after 5 years, or at least I could go to the bank and mortgage it, well, I could start a business or something like that. Or now, if I were a college student and I got 160 acres, but I'm trying to keep my car running, because I'm a college student, I'm trying to make sure I have enough to eat next week and that sort of thing, pay rent. The one thing you could do is, you're going to have to start paying taxes on this. Okay, so you've got this 160 acres. What can I do? Well, I could go out, I could mortgage it, and maybe I could rent it out, right? I could get some cash immediately, and then I could start renting it out. So it's going to make some money for you, okay? So there's a lot of things you can do with it. Maybe growing marijuana would be the best thing to do. That's we gotta wait for the laws to change. But all right, so or wine. Maybe you could start a vineyard or something, a small amount of land. Okay, so why am I even talking about that? Because the Dawes Act was intended to be beneficial to the Indians. And the people like Henry Dawes and the Friends of the Indians, they're actually a group of New Englanders that they call themselves the Friends of the Indian. They had annual conferences just like academics do. They would go to Lake Mohonk, New York, and they would hang out for a week and eat really well and probably have parties and drink a lot and then talk about Indian policy and how they needed to change things for the poor Indians out on the Great Plains. Much like academics. So the idea here is that the Dawes folks, the allotment people, were thinking of how to help the Indians out in the West. And they realized that, if those Indians were assigned individual parcels of land, it probably wouldn't be very long until those nasty Westerners are able to swindle them out of that land because they're ignorant Indians, all right? And they don't understand the market way of life, the free enterprise capitalist way of life. So what we need to do is we can't just do this like the Homestead Act, where they only have to be there for 5 years, like the Indians were going to go anywhere. So that the homesteaders are there for 5 years, and then they get a title, and they get to go to the bank, and they mortgage it, and they get a loan for agricultural improvements, building a house, building a barn, building fence, buying cattle, whatever. But for the Indians, if we did that for the Indians, then you know what would happen. They would just lose their land immediately. They would, half of them would trade it for whiskey, right? That's what these people are talking about. These people are saying we can't allow these people to lose their land. Okay? So they create a system where land is given out just like the homestead. Okay, so you got 160 acres more or less for every every male native person, and it depended, but generally this is 160 acres was considered a good farm, big farm, just like the Homestead Act. But rather than filing and requiring somebody to pay a nominal fee after 5 years to get a title of that land so that they can then sell it, well, in the case of the Indians, the people at Lake Mohonk said, what we'll do is we will give them we'll assign them the land, and then they'll need to be on that land and farm it for 25 years, and then after 25 years, they can apply, they can get a title to it, okay? Then they can sell it, okay? Now, one of the fears also is not just this potential for whites to swindle Indians out of their allotted land. Another one was the fact that the states where these reservations were located, or the territories, could do things like tax them. And if they taxed them, and these people were just subsistence farmer, didn't have any cash, then the state could actually evict them from their land. So one way of protecting them from a seizure for tax purposes was to hold on to that title, for the federal government to hold on to the title. So that's one justification. But for the most part, it was about, if they said, okay, this is going to be your allotment, you can live here and farm it for 25 years, but you're not going to be able to sell it because the federal government's going to hang on to that for another 25 years. So what do you think about that? Would you take the 160 acres from the federal government, live on it for 5 years, file a nominal fee, and get a title to that land, yeah, that sounds fine to me. I'll go sell it as soon as I possibly can, just make some cash. But if you're an Indian and you get this allotted land, the federal government's going to have it for 25 years. Well, what if you're like my age? 25 years from now might be history for me, okay? I may not be here in 25 years. So what do? Well, I could put my blood, sweat, and tears into creating a farm like the government wants me to do. But there's no guarantee that if I put my blood, sweat, and tears and money, labor into that place, that it's really going to be mine in 25 years. How do I know that? It's the federal government after all, and look what they've done to us so far. So the question is, is there a real incentive there? Is there a guarantee that this land is going to be yours? So what would you do in that case? Say you got the 160 acres, but you're not going to be able to sell it for 25 years. What's your next plan?
Can your spouse take it or not?
Let's say your spouse is also an allottee, and she got 80 acres because she's a woman, which is what they did. Okay, sorry.
No, I mean,
I don't have my glasses on. Yeah. Okay. So together you've got 240 acres. And you got a couple of kids. You got another 80. Okay, so you got 320. That's a half section. That's great. Big spread. Lots of land. You don't have title to it. So what are you going to do with it? Well, you can kind of live off of it. What would be your immediate response?
get cows.
Get some cattle?
Yeah.
Okay. You going to the cattle market down in Perkins?
I don't know. Let's say if that was all I had.
No, that's fine. That's fine. That's fine. So you want to run some cattle on it, okay? If you were to buy 10 head of beef cattle, 20 head of beef cattle, how much is that going to cost you? Right off the bat. Several $1,000s at least, right? $10,000, $15,000 maybe, I don't know. Probably $700, $800 a piece these days, I don't know. But you're gonna buy some cattle, but then with what? Your good looks, okay? That's my stepdad would always say. You're gonna buy that with your good looks. In other words, you don't have any capital. You're an Indian with 320 acres that you don't have a title to, okay? And no bank is gonna even listen to you when you say, well, you know, they ask you what collateral you have to buy the cattle and the fence and the feed and vet bills. Okay, well, maybe not in 1887, but you know, today I'd have to have a Ford F-250 Super Duty and a big gooseneck trailer and a lot of good fence and vet bills and a lot of land. That's not cheap, so I'm not going to get it on my salary. Anyway, the bank's not going to give you any money because you don't have any collateral. They can't repossess your land like they can the settler down here in Stillwater who just filed on that 160-acre homestead and got his title. He takes it down to the bank. That's what my great-great-grandpa Walter did. He got his homestead title. He got his title down in Guthrie. First thing he did is go to the bank, cash that sucker in, start building, buying stuff. But he had to wait 5 years. In the case of the Indians, it's not coming to you, and no bank's going to repossess the land from the federal government. So you're land rich, but you're capital poor for the most part. this is the problem with most trust land today. That even if you are living on an allotment, say you put a lot of money into fixing up a house on that allotment, well, you're not going to get that back. You're going to use it maybe, but you're not going to be able to sell that and get your money back. That investment is only for use, as long as you want to live there. Okay, so anyway, here's the academic plan to fix all the problems without realizing that there really aren't a lot of solutions in the world. There are a lot of trade-offs. And here you've got a trade-off. In the case of the Dawes Act, yeah, you can distribute that land to those individual Indians, and now they're living on individual allotments that are just like little reservations because they don't have property. It's not there. It's very different from a homestead. The reservations get allotted, and a typical example would be to have a tiny fraction of the total land area actually gets utilized, and then all the rest of this becomes what's referred to as the surplus land. Surplus land is then it's public domain land, and there may be a payoff to the tribe or something for the ability to take that land and distribute it to non-Indians. Often that was part of the deal, to sweeten the pot for the allotment agreement. The Dawes Act, however, pretty much standardized this for a lot of tribes, and so what you have is, some tribes were dead set against it. They said, absolutely not, we don't want anything to do with this. And that would include the 5 civilized tribes of Indian Territory. Okay? So how did the 5 civilized tribes fight it in 1887? Actually, way before 1887, they saw it coming down the road. They had lobbyists in Washington, D.C. working for them, lawyers, to persuade people who were pushing this idea that, the 5 civilized tribes, we don't need allotment. They were against that. They had other deals with railroads, for example. So they were able to maneuver legally away from this, and they got exempted. The 5 civilized tribes, because they were so civilized, because they were so politically astute and sophisticated and connected, they got an exemption from the Dawes Act. They were omitted from it. So the people who were probably most ready to become individual farmers and homesteaders were the ones who were exempted from it. And the people who were probably least prepared to be farmers were who? There were people like the Ponca, who were buffalo hunters who got beat up by larger tribes like the Lakota. Got a real small reservation up on the Niobrara River, which is their homeland, but then were forced out of that because the United States government was playing favorites with the Lakota. The government would allow the Lakota certain advantages because they couldn't control them. So the Lakota kind of expanded. The Poncas eventually came down here to Indian Territory just to get a reservation that was kind of a refuge. So the Poncas wind up, they're people who were, it's not that they never farmed, but they were not necessarily farming people. And the Poncas came to Indian Territory, so it was actually not so bad. But if you look at like a lot of the reservations that got allotted that are on the high plains in areas that are prone to drought, and not only prone to drought in fairly dry areas, but incredibly isolated from any market where any farmer in his right mind would ever want to go. Okay? So here's the government saying, okay, you Indians out here in western South Dakota, you need to start growing corn and start farming wheat on your 160 acres, and then you can make money at that. In western South Dakota? Okay? None of the white farmers are in western South Dakota growing wheat. They're only raising cattle, okay? Because it doesn't make any sense to grow wheat. There's far too distant from any urban market, at least, maybe for the time being. So isolation, environment, experience as farmers, as cultivators, were all pretty much strikes against a lot of these tribes. Their isolation, their distance from markets, their living in areas that are prone to have climates that are really not very good for producing market-oriented agricultural products. So you have, what is your alternative? Nobody's ever really come up with a solution here. Well, I mean, if I had this 160 acres and maybe some cattlemen wanted it, I might lease it to them. Say, yeah, you can run some cattle on this. Sound like a good idea? So why didn't they do that? Well, maybe some of them did. One of the problems with Indian title, or with restricted trust land, is that if it's trust land, then even though you have the right to use that land and you have your right to use your allotment, you cannot make, because of other things, you cannot make a decision in order to
you can't transfer usage.
you can't write contracts, okay? You can't write a contract for that use. You're not going to be competent in a court of law, so you can't hold a contract. So what happens? Who has to? If you're going to lease it, what has to happen?
You have to go to the government.
It has to go through the government, the Indian office, right? So they have the ability to do this, so you have to talk to your Indian agent if you want to lease it out to somebody. Okay, so that's a strike against them as well. Now, going to the 5 civilized tribes, okay? Remember how their title was a little different? If their land is considered more of an estate than just Indian trust land owned by the federal government, then the problem is you've got these huge areas of land in what is today eastern and southern Oklahoma. And maybe you have, let's say, in one of these Indian nations, 16,000 people living across what is today, 12 counties in Oklahoma. 16,000, that's not a lot of people, right? I mean, that's what you get. That's just like a quarter of Boone Pickens Stadium, right? Something like that. There's not very many people across that very broad area. So, but the problem is the government can't legally give them 160 acres and say we're all square, because it's like a big family of 16,000 people where all the land has to be divided equally, right? So that meant that in the case of the 5 tribes, that land had to be distributed in a different way, okay? And it's a really convoluted way that they did it, but basically they would say each tribal member, depending on the agreement in the tribe, each tribal member gets an equivalent acreage to some number. Like the Cherokees, I think, was like 210 acres. The 210 acre equivalent, whatever that means. And the way they would calculate the acreage was they had over a dozen different land classifications, and it's like, okay, you get, if it's really lousy land, then it's worth more than, you know, the standard acreage. And if it's really good bottom land, then it's worth more. It's worth more? What do I say? If it's really stony, rocky, slopey land, then it's going to be valued less. So you would basically get kind of like buying shares of land. And so then you would get the equivalent of so many acres based on that land classification. So it depended on where you took the land allotment, okay? But they made it even more difficult. And this is probably the tribes doing this, but in the case of the 5 tribes, not only did they get their allotment, but they got two different allotments. So they got what was referred to as a homestead allotment. And they got what they referred to as their surplus allotment. Okay? And the homestead allotment was a smaller parcel of land, a smaller proportion of the total parcel. And the surplus land was often a discontiguous parcel of land. All right? So it was often the case that here's your tribal domain, that Sally Sixkiller, all right, gets her 50-acre homestead allotment over here in hilly, rocky land along 14-Mile Creek in what is today Cherokee County, okay? And that's where she lives, and that's the land that she wanted to claim for her, because she already lives there, all right? After all, that's where her farm is. But she can't really claim the land around her because her neighbors own that, and they're claiming it for their homestead, right? So she can claim this small amount of land as her homestead allotment. Then maybe she's owed 200 more acres of decent land. She's in rocky, hilly land. And there's no area around her where they can designate that because she has neighbors around her. So, and she's not traveled very much out away from her 14-Mile Creek homestead any of her life. She doesn't know much about the rest of the state or the rest of the area. So the commissioners of the commission or whatever say, okay, well, Sally, you can also own a homestead allotment way over here on the Arkansas River near Tulsa. And this is going to be, actually it's south of Tulsa in this little place they call Glen Pool. You ever heard of that? Glen Pool? And over here we're going to say that you get this land, and over here in this place called Glen Pool, I guess Glen Pool's Creek Nation, that doesn't really work. So maybe she's in the Creek Nation. Her name wouldn't be Sixkiller, it'd be something else. So anyway, she gets this other allotment over here near Glen Pool, and it's maybe 150 acres. Okay. And this is surplus allotment, and this is the homestead allotment. Now the homestead allotment, in the case of the Cherokee Nation, and I can't speak for the other 4 tribes, in the case of the Cherokee Nation, the homestead allotment was going to remain in trust for 20 years. Okay, 20 years. So it's not as severe as 25, and it's only for the homestead, because the surplus allotment, right? The surplus allotment only has a 5-year period. 5-year period before you could sell it, before you get a title. Oh, wow. Okay. So this is like the example of the Cherokees. All the 5 tribes were similar to this. And the reason they did it like this was because when they didn't have GIS and they didn't have algorithms, but they had the ability to figure out how much land they really needed to. No, they didn't have the ability, but they tried. There was lots of mistakes. But the idea was that they would divide up the whole estate equally among all of the tribal members, right? Sounds like a good idea. But they would have the homestead so that people could claim where they actually lived, but then they would get the equivalent somewhere else. They may never go to Glenpool. Okay? So after 5 years, guess what happens? Somebody shows up at Sally's door and says, I understand you own this chunk of land over near Tulsa. Have you built anything on it? No. Have you ever been to it? No. How would you like me to take it off your hands? Okay? And so this is, maybe after 5 years, maybe she's gotten title to it, or maybe she was going to get title to it. And this guy says, okay, 150 acres, we're going to give you $500 for it. And she says, I'd never get $500 for that land. I've never been there. I'll take it. Okay, sounds good to me. So the guy says, okay, well, we got all the paperwork taken care of. Just sign here, there. That's that. Okay. Now, she's still living in her home. She's fine. She's got a nice chunk of cash. And what happens in Glenpool? Massive oil strike. Well, we didn't ever talk about the rights to the mineral wealth, did we? In the case of the 5 tribes, the mineral rights were allotted with the land. That $500 sale that she was real happy with, the land was worth $5 million. Okay? Possibly. So the mineral rights went with the land in the case of the 5 tribes. And so, yeah, there were people who lost huge amounts of wealth. But then there were some people who made a lot of money, too. Oil strikes in Glenpool and Red Fork and Cushing and other places. So we've got a little differences here with the surplus versus the homestead, the alienation period. By the way, that term alienation refers to the time or the process of the federal government handing over a patent to the individual land holder. All right. Now, in not too long after most of the allotments were made, and I think I said last time, most of the allotments were made by the time of World War I breaking out. Remember that? Those allotments, that's about the same time when some of the huge oil booms were happening in places like Glenpool, earlier than that, I guess. And people were getting wealthy. When the 5 tribes allotted, how did they allot? Why did they do it? They were exempt from the Dawes Act. There was another law. I don't know if you've read about it yet. A law passed in 1898, and it's referred to as a lot of things, but the Curtis Act is the easiest to remember. Curtis was a Kansas senator. Was he a congressman? But he was the first American Indian in the United States Congress. He was a member of the Kaw Nation. And the Curtis Act of 1898 basically was the federal government's sort of ultimatum to the 5 tribes. Now, I have to back up a little bit and say that in the 1890s, after 1887, after the 5 tribes were exempted from the Dawes Act itself, the federal government sent a commission headed by Henry Dawes, referred to as the Dawes Commission. And the Dawes Commission's job was to go through Indian Territory and negotiate with the tribal governments to get agreements to allow them to allot their land. And the tribes put everything they could into stopping this. They stonewalled them. They tried to confuse them. In some cases, they got their citizens to avoid the signing of the roll in case of the creeks, so that a lot of people didn't get on the roll that should have been on the rolls. The rolls were lists of names and blood quantum that the government commission guys went around, and basically they're signing everybody up to get allotments. So they're saying eventually there's going to be an allotment. You need to get on the roll. Okay, and we're going to also list your blood quantum here. So those were referred to as the final rolls of the 5 civilized tribes. And if you are a member of any of the 5 civilized tribes, then you have an ancestor who was on that roll. If you don't have an ancestor's name on that roll, you can't prove that they're your ancestor, then you're not a tribal citizen. Okay? You have to have an ancestor on the rolls. So anyway, the allotment was made based on these rolls. And this was all done in the early 1890s, 1893 actually. And they were getting nowhere. So after about 5 years, Congress passes this thing called the Curtis Act, which pretty much just laid down the law and said, okay, if the tribes don't come to the table and negotiate individual allotment acts, then this is the plan that will take effect at this time, on this date. And the allotment plan that they gave was pretty severe, and it wasn't going to be a very good deal. So when the clock started ticking in 1898, then the tribes started coming to the table and negotiating. 1898, 1899, 1901, and each of the tribes came up with their own individual allotment agreement, because there were no treaties yet anymore, remember? So the allotment agreements were those things that they were usually a little sweeter than what the Curtis Act allowed. So the allotment agreements were passed in order to avoid the Curtis Act stipulations. And that's about it. We're done. We're out of time. I hope that was, I know that was probably really confusing. So keep in mind that a lot of the stuff we're talking about is connected to land and title. The ability to sell your land is everything. Okay? But people with good intentions often don't make things much better. Sometimes they make them worse. All right. Well, have a good weekend.